Hello, good afternoon, everyone. Welcome to our webinar. Thank you for joining us today. Thank you to those who are here early. While waiting, allow us to share with you a video from the firm.
I founded the firm in September 1985 with the vision of seeking truth and justice for our clients and not just winning their cases. Over the years, the team has achieved many significant milestones. We are today recognized by the Legal 500, Asia Law Profiles, and Asian Legal Business as a recommended firm in various practice areas. While we have embraced technology to make our services efficient and responsive, we continue to grow on the bedrock of meticulous preparation and hard work, for which there is really no substitute. As legal practice becomes increasingly international, we keep ourselves ahead of the curve with our relationships with lawyers from around the world. Our firm is a founding member of the League of Lawyers, a growing international network of law firms in 20 Asian and European countries.
We believe in partnering with our clients to protect and grow their business. We achieve this by holding firm to our values of integrity and justice, while giving our best to deliver effective and efficient solutions. Instead of just legal services, we focus on developing great working relationships based on understanding and respect.
We regularly advise foreign clients, including many Chinese investors, and have a ready appreciation for different ways of doing business. In corporate matters, we offer relevant and commercial solutions, often raising issues that clients may or may not have realized before. In negotiations, we believe in facilitating win-win outcomes.
So again, allow me to welcome everyone for joining us today for today's online talk. The talk today is entitled Software Development, What to Know About the New Standard Form Contract by AIAC. My name is Anis Haimi. I'm an associate with Marvin Coyne Associates. And before we start today, allow me to introduce the firm and what we do. Marvin Coyne Associates is a mid-sized law firm that was founded in 1985 by Dr. Marvin Coyne. Our able team today comprises of 27 lawyers and 31 staff. Datuma is a consultant with the firm following his retirement from the Court of Appeal bench in 2015. The firm continues its tradition today of working with primarily SMEs, family businesses, and individuals. We are a full-service law firm with corporate departments, dispute resolution department, including litigation, adjudication, and arbitration, and a dedicated employment team and department focused on servicing the needs of individuals and families. Our firm also has practice groups, and these practice groups indicate some of our focus areas which are supported by talents from both our corporate and dispute resolution teams. Today is part of our MWK online talk series. By way of background, we have been organizing monthly lunch talks at our office since 2013, some of which were also broadcasted live. But with COVID MCO, we moved online in order to continue our objective of sharing knowledge, raising awareness, and encouraging networking for clients, potential clients, and in-house counsel. This is our 14th talk of the year. Please visit our website if you want more information, to read our articles, and to sign up for more upcoming talks. Before I continue, please be reminded that this talk does not constitute legal advice. In the event you require specific legal advice to your matter, please contact us for a complimentary legal consultation. Details will be provided at the end of the talk. For today's session, we will have two speakers. Tommy will be speaking first and followed by Cassandra, and they'll be speaking on understanding software development contracts and important clauses, as well as on the AIAC's new standard form of contract. So before you on your screen is our lovely Cassandra. She heads our corporate department. She holds a bachelor degree from Northumbria University and a Master of Law from King's College London. She was admitted to the Bar of England and Wales in 2011 and was admitted to the Malaysian Bar a year later. Cassandra's practice areas are primarily focused on corporate and commercial matters, such as drafting corporate project agreements, mergers and acquisitions, joint ventures, software development agreements, and support and maintenance agreements. Supporting Cassandra in today's session and in the corporate department every day is our dashing senior associate, Mr. Wong. Tommy obtained his Bachelor of Laws in 2015. He was called to the English bar in 2017 and admitted to the Malaysian bar in 2019. Tommy is also primarily focused on corporate and commercial matters, including construction contracts, project agreements, licensing IP rights, and regulatory compliance. After our speakers have present their topics, we will conclude with a Q&A session. So if you have any questions, please don't forget to type them in the Zoom's question and answer chat box. With all that said, I now invite our first speaker, Tommy, to begin.
Hey, thank you so much for the kind introduction. I didn't know you thought of me as dashing. Okay, good afternoon to you guys, ladies and gentlemen. Thank you for tuning in today for our 14th talk of the year. Today we'll be talking about software development contracts and also the updates in terms of the standard form contracts set by the AIAC. We have actually touched on this topic before, but I think today we will be more focused on the standard form contract established or issued by AIAC. Now, today's world, in the modern world, we are heavily influenced and dependent on our access to technology and certain software features. Now, to be straightforward, we all rely on our phones and laptops significantly, and all of which our devices will have certain applications, platforms, individual softwares installed, either from the App Store if you are an iPhone user, or even Google Play if you are an Android user. Now, technological advancements have been rampant in the past few years, particularly because of COVID and the restrictions of physical movements because of the pandemic. Now, with the development of technology, we have grown our global access to industries, markets, and even businesses and transactions with loads of efficiency and effectiveness. Technology has also brought upon entertainment to each and every one of us in its own right. For instance, children are consistently playing their phones or devices, and they are thoroughly engaged in platforms such as YouTube. Teenagers or even young adults are constantly on Netflix, browsing through Instagram, Facebook, subscribing to Disney Plus, and all sorts of things. And for working professionals, we rely on LinkedIn, Wikipedia, or other research sites, other platforms, and we also communicate via Zoom, Google Meets, or even Microsoft Teams. But I believe that each and every one of us who are using a telephone device or even a laptop, we will be highly engaged in what we use on a daily basis, the app called WhatsApp. Now, more and more software and applications are being developed and launched. Some advance to instant popularity and adoption. The others fall to their failure. Today's online talk, we will touch on the point of software development contracts, and also the emergence of the AIAC standard form contract. Now, the term software is rather generic, and it usually refers to applications, scripts, programs, and codes. Software development refers to the design, development, programming, testing, and the continuous maintenance and support of a software deliverable. The combination of these steps are used to create a workflow pipeline, a sequence of steps that, when followed, will produce a high-quality software deliverable. Software development includes, or rather involves, a software developer developing the software product, and also the client who will then receive the product and then use it for its intended business. And sometimes we do have to understand that not all software developers can have that expertise to develop the intended software product in its entirety. Some software developers can have the right to assign certain parts of the scope of work or services to a third party. And this is something that we can dive in due course. Now, the end result of the software development process is the software product itself. Aside from the development of the software and also the terms and conditions of the contract, what we have to look at as well predominantly is the intellectual property rights that come along with the software being developed that has arose out of the contract or in connection with the course of the contract. Now, the intellectual property rights are usually vested with the client, but these intellectual property rights do not include those that were already owned, possessed, or possessed by or belonging to the developer or any other third party before the commencement of the software development contract in question. Now, how people or how parties negotiate on this must be very clear so that there's no gray area or blurred lines between what constitutes intellectual property rights arising out of that particular software development contract. Now, the design, development, functionality, technicalities, and specifications of each software are different. They are unique and they don't, although may be similar, but they are different in their own individual rights. Now, the earlier part of a software development process will include a coming up with a solid methodology, underlying structures, process models, and also a storyboard. A general overview of what a software development process would look like is essentially coming up with the requirements, analysis, and also specifications and design. Then there will be the design and development phase, and then after that, multiple phases, depending on how detailed you want the testing to be, the testing phase. And then also following that would be the deployment of the software or even a go live phase of the software. And then thereafter, it will be the continuous maintenance and support of the software or even the end product upon its launch or deployment. That will be conducted subsequently after the launch. So how do the developer and the client set out in writing their agreed terms and conditions or even obligations in a set piece of paper? Or rather, what would you call such a document that governs a software development project or process for the matter? Anybody can name the contract anything, but it is usually closely tied to what the nature of work is. Now, because it is a software development project, it is more commonly referred to as a software development contract or agreement. A software development contract is essentially a service agreement between the developer and the client governing the terms and conditions under which the development of the client's intended software will be governed. A well-drafted agreement or contract is essential for any transaction for the matter, whether be it software development or even sale and supply or even construction contracts, any transaction for the matter. Hence, in this regard, for this particular instance, in terms of software development, the contract must clearly set out the rights and obligations of the parties involved in the whole process itself. This would also help the parties by mitigating or reducing the risk of uncertainty and also future disputes between the parties arising out of the contract. And it would also safeguard the interests of both parties or all the parties involved altogether, depending on how many you have. So now these are, I presume, some questions that most of you or some of you may have entering into this online talk. Now, every party to any agreement for the matter will have an intention to protect their rights and also their interests to be safeguarded in any and all aspects. Clients usually say you want the agreement to be watertight, and that goes without saying. So in terms of a software development contract, we will then touch on what are the more important clauses and terms of a software development contract. Now, before the AIAC standard form of contract for software development, very usually software development contracts are commonly tailor-made or specifically drafted or prepared to the specific needs of the client or the developer. Now, these contracts are what we usually call bespoke contracts. Bespoke contracts are those that are, again, tailor-made and specifically tailored to the needs of the parties involved. Now, because each software will have its unique print, program codes, or rather source codes, and design and specifications, their own functionalities. These attributes will be clearly set out in the contract itself. And thus, the terms of each contract may differ, not a definite difference, but there may be certain aspects that will be different, and even obligations or rights may differ from one another, which is why it's a bespoke, not a standard form. Now we can quickly dive into the important clauses and terms for a typical software development contract that is drafted in a bespoke format as opposed to the standard form, which Cassandra will touch on later on in this online talk. First and foremost, I think the main gist of the contract will basically set out the service timeline and payment terms. Now, the services clause, it will definitely set out the nature of the service and the scope of service that the developer will provide to the client, and also in what manner the software will be developed. It also involves or includes under the heading that what kind of software will be developed. Now, the type of software to be developed will be generally put under the clause, but the specifications, the technicalities, functionalities, design, development, and all these nitty-gritty details will be usually attached to the agreement as an appendix or schedule, so as to ensure that the main body of the agreement is not complicated and not too messy to make things more understandable. Now, alongside the scope of services, the nature of service, type of software would be the project timeline. Now, this is important because every client will have the projection on when would be the first trial, second trial, final trial before launch. So there are timelines to be met. Now, the developer will then have to meet the timeline of the client, and this includes the commencement date, the handover of the software, the testing date of the software, when must it be tested by, what are the milestones, and also essentially what is the term of the contract. Now, the term of the contract may be slightly subjective because there may be a support and maintenance aspect included in the contract, or it may not. That I'll touch in a short while. Now, the project timeline sets out the entire timeline of the project. That is the clause, as the name suggests. But even though there are timelines and milestones set out, this clause heading will also provide terms for under which the developer may request and also the client may grant extensions of time if it is reasonably foreseeable that there may be certain delays, unforeseen circumstances affecting the delivery process itself. Now, for any and all transactions, what else is more important than money and how money is being paid? The contract sum will be a big part of any contract, and how the money or contract sum is to be paid, whether by milestone or lump sum or installment basis, that is completely subjective and depending on how parties agree to the terms of payment. Now, I think more importantly, because money and product itself themselves are primarily the main aspects of a contract that will cause disputes or misunderstandings between parties. First, the terms of payment and also payment milestones, and also the manner of payment must be clearly and expressly set out very carefully in the agreement. And this would then really mitigate the risk of misunderstandings or differences or disputes between the parties. Now, although the scope of services are closely linked to specifications and drawings of the software or the deliverable, there may be variations to the scope of services. These variations refer to changes to either the design, quality, or quantity, or even the scope of services to be provided by the developer to the client. Now, variations may result in additional cost or negative cost being a cost reduction in terms of the contract sum. If let's say if it's 1 million, but there's a negative variation, it may very well be reduced to a contract sum of, let's say, 950,000, 800,000, depending on the extent of the negative variation in requested or approved or even involved. When the software is developed, whether be it as a pilot phase or a first sprint or second sprint, it is of utmost important that the software or the product itself undergoes several phases or a predetermined number of phases of testing to ensure that the product itself does not have any defect or malfunction or even a failure to satisfy the specifications or design or functionality of the intended end product. Again, there may be several phases of testing, but commonly or usually the phases of testing would be testing conducted by the developer. And then thereafter, upon the first round of rectification of any found defects or discovered defects, then there will be a final testing conducted by the client. Now, ultimately, services must be provided at a reasonable standard of care and expertise by the developer to the client, and to ensure that the product is developed to the requirements of the agreement or the drawings or designs or specifications or technicalities or even functionalities of the product. No more, no less. That is what testing is for. We have mentioned about delay in terms of extensions of time. Now, liquidated ascertained damages are what we usually call LAD, and they are a form of compensation that is provided or payable to the client in the event there are any there is any event of delay towards the completion of a milestone or even a completion of a project. Now, LAD and delay is important because then again, compensation is money, and any delay towards the completion of the project would then result in the delay of the launch. Delay of the launch would then result in possible loss of profit or whatever aspects of the financial projection that the client may have in terms of the launch of its project. Now, under this clause heading, then parties can agree and should agree to a predetermined rate of compensation in the form of LAD, and this would then completely avoid any form of dispute as to, oh no, I'm supposed to pay you this only for delay, or I'm not even supposed to pay you. So it really contributes to the elimination of squabbles between the parties in terms of compensation. Obligations of the parties, important because, as the name suggests, obligations of the parties are set out clearly and precisely, and these obligations are to be fulfilled by each party respectively. And if parties do prefer it to be this way, the clause may be very long and very long-winded. Some contracts do put the entirety of each party's obligations in the main body of the agreement, or it can be very generic in the main body, but reference is made to an appendix or schedule of the contract, and let's say Appendix B can set out the obligations of the developer. Appendix C may be the obligations of the client. And with that all being typed out and documented in writing meticulously and carefully, these specific obligations and general obligations of each party must be observed and fulfilled. If not, then there may be a default or even a breach of contract. Now, as mentioned earlier, intellectual property rights, they are tied to the development of the software, and also they are tied to the cost of the contract itself. In terms of softwares, the intellectual property rights clause would be one of the most important clauses to look for. There needs to be a clear distinction that any intellectual property rights that were already in existence and belonging to the developer or the third party will remain with the developer or the third party, as the case may be. That would be before the commencement of the software development contract. Now, when it comes to a software development contract, certain aspects may have IP rights being attached to, let's say, certain source codes, this and that. There may be a fine line of blurriness as to whether the source codes belong to the developer or the client. Now, that is why negotiations are important, understanding between the parties are important, and this particular IP right clause is of utmost importance in terms of clearly setting out what IP rights belong to who. But ultimately, in the end, it is very common that the product developed under the contract and any part relating or in connection thereto will be attributable or will remain vested with the client upon the handover of the product. In certain cases, ownership may also be already vested with the client even during the development of the product itself. Now, confidentiality, it is a boilerplate clause, but very important because this maintains confidentiality between the parties or any other party involved during the development phase, during the implementation phase, and also the deployment phase, so that nobody wants their secrets to be out there in the public. Under the confidentiality clause, this would be an obligation on the party, tying back to the obligations of parties clause, that imposes the obligation on each party to maintain strict confidence of any and every information, detail, notice, letter, whatsoever, not obtained by each party as a result of their contractual relationship under the software development contract. Now, as I mentioned, there is an aspect of support and maintenance being either tied to or tied directly in the software development contract itself, or the aspect of support and maintenance can be separated from the software development contract as an independent, separate, definitive agreement altogether. Software support occurs by fixing or rectifying defects or what we call bugs, whereas software maintenance occurs where additional features are to be added or installed or implemented to reduce the software technology, they age too, right? So to reduce the aging of the software, or to even mitigate the deterioration of the software, or to even for the purposes of updating the software to make sure its functionality is on par with newer technology. And this would then enhance user friendliness and also easy access and easy usage by customers and end users altogether. Support and maintenance are two very important aspects of software development or even software products due to the constant need for it to be improved, updated, and also be rid of bugs. Who likes using software applications with bugs? Imagine if your WhatsApp is always crashing. So support and maintenance is important. Parties have to determine whether support and maintenance is to be included in the software development contract itself, or it is to be a completely separate agreement. It can be in the form of service levels, or even just a support agreement or maintenance agreement. It really depends on the nature of transaction that the parties intend to enter into. What are the other important clauses? Boilerplate clauses, they may be very standard. They may be found in each and every other agreement, but there may be difference between these boilerplate clauses, although they are standard clauses. The force majeure event is defined as any unforeseen or unpredictable event that prevents a party or both or all parties from performing or fulfilling or observing their obligations under a written agreement. Now, the clause would then excuse or give reason for a party to excuse itself from performing the contractual obligations should there be such an event that is beyond the reasonable control or foreseeability of the affected party. Now, force majeure has come into a big block of light in recent times because of COVID-19 and also the MCO. So, for example, a force majeure event can be acts of God, acts of terrorism, acts of war, pandemics, epidemics, movement restrictions, governmental orders, or even governmental lockdowns or travel restrictions. What constitutes force majeure? Parties can freely negotiate to put whatever they think is reasonable to be included there. Now, termination, important. If you don't have a termination clause, then it's a bit of a headache. You probably scratch your head like thinking, no, this contract didn't go according to plan. How can I terminate this contract? So it's important that this termination clause is carefully and generously drafted. Termination clause is considered as an exit strategy in the consequence of a default of obligations or breach of contract, or the contract can even be terminated for convenience. Either party can opt to terminate the contract by providing a written notice to the other party that is no less than, let's say, 30 days, or 60 days, 90 days, just for the sake of it. Whether or not termination for convenience should be included, that really depends on the negotiations between the parties. Usually no, because who wants to give the other party a right to simply terminate just by giving written notice? So usually the termination clause will only be catering for default and breach of contract by either party, so that the other party can have the right to terminate the agreement and claim for whatever you're owed in dispute resolution. Governing law, because we're in Malaysia, it's usually contracts are governed by the laws of Malaysia. But in the event, if it's a cross-border transaction, let's say Malaysia and England, parties then have to negotiate and determine what rules, or rather which jurisdictions' rules or laws will apply to the interpretation of the terms under the contract in the event of a legal dispute. So that is very important. Let's say if it's to be governed under the laws of England or English law, then unfortunately the laws of Malaysia will not apply. If we are in Malaysia, then obviously 99% of the time it will be governed by the laws of Malaysia. But if parties are, let's say, big time parties or big corporations, public listed or this and that, they may opt to even have it governed under the laws of Singapore for the matter. So it really depends on the parties to see how they want to resolve their issues and what avenues they want to take. If that happens, touch wood. Tying that closely with termination and governing law is the dispute resolution clause. That is very important because it sets out the procedure under which the parties will rely on to resolve any claim, difference, or dispute between them arising out of the software development contract. Now, dispute resolution, it is usually drafted in a way where if parties have any claim, difference, or dispute between them or amongst themselves, they will use their best efforts and endeavors to resolve such issues between them by way of negotiations. Now, how long for parties to resolve amicably via negotiations? It may be 30 days, 60 days, 90 days, depends. How many chances or how long you want the negotiations to take, or how long you want to set the limit to be, completely up to you guys. But yeah, it is always encouraged that parties negotiate first before they resort to court proceedings or even arbitration. Which brings me to my next point, dispute resolution. If in the event negotiations doesn't work out, you can either refer it to arbitration proceedings or even court proceedings. What are the main differences that I can point out right now is the aspect of confidentiality and also the cost that comes along with each. Now, arbitration is known to be more to maintain a very strict level or strict degree of confidentiality in terms of proceedings, but the cost comes much higher because you have to pay for the venue, you have to pay for the arbitrator's cost, and also your legal representation in arbitral proceedings. Now, whether it be court proceedings or arbitral proceedings, it really depends on the parties to see what would be to your taste buds in terms of future incurment of cost in the event of dispute. Let's say even if parties are willing to go for the more expensive route in the form of arbitral proceedings, whether it is to be determined or resolved by one arbitrator, two arbitrators, 3, 5, to be jointly appointed or solely appointed, I mean, that is really subject to how parties negotiate. That is why I can safely say that even though boilerplate clauses are quite standard or very common, and you see them in any and every agreement, but how they are drafted that will allow you to handle certain issues in the future in a certain particular way, that is on you guys. And that is something that you have to think and consider before you sign the contract. Yeah, lastly, and I think this is my last slide, counterparts and entire agreement seems to be the most general clauses altogether. But now the counterparts clause is usually overlooked. This clause would usually make things a whole lot easier for parties, especially when it's a cross-border transaction, or even if one fleur is in Kedah, one fleur is in Selangor, not particularly convenient for them to come to a physical meeting place to sign the contract. This clause makes it easier. Why? Because it allows parties to the contract to allow them to execute separate copies of the contract, and then thereafter, with the separate copies or separate executed copies of the contract, they can be read together as one. So like, let's say party A signs this one, party B signs this one, they put it together, it is one. Thank you. And lastly, the entire agreement clause is essentially a clause stating that the parties to the agreement acknowledges and agrees or agree that the terms of the contract are found nowhere else but in the contract itself. So whatever said prior, whatever said before, whether be it was a letter before the signing of the contract or whatsoever not, those are all superseded. So this agreement or this contract itself is the one and only contract that contains all the agreed terms and conditions between the parties. Courts support this because this clause provides a high degree of certainty that the terms of the contract are exactly what the parties intended to and also agreed on. So with that being said, I've come to the end of my presentation of the usual bespoke software development contracts and also the process of software development itself. Now that the AIAC, they have come up with a standard form contract for software development, I am very pleased and happy to pass the floor and also bring your attention to Cassandra, who will be able to take you guys through the AIAC standard form contract. And I hope you guys had a good, insightful journey with me. I'll pass you on to Cassandra. Thank you. Cassandra, on to you.
Thanks very much, Tommy. Hi, everyone. I hope you guys are having a good Wednesday afternoon. I am conscious of time, so what we're going to go through, you guys can see my screen, there we go. And we're going to take you through the AIAC contract in terms of the standard clauses, which Tommy has covered most of them. So I'm going to show you where it's placed in the AIAC contract and how it's customizable. So to introduce the AIAC contract, what they had initially done was they engaged several technology industry players, which comprised of companies from the IT companies. It also involved several lawyers in Malaysia and internationally. And what they did was they had a virtual roundtable and they conducted several surveys to gauge the industries, especially for IT in Malaysia and outside Malaysia, for software needs. As a result of this research initiatives and the discussions between legal advisors and people in the IT industry, the AIAC then decided to launch a technology expert committee to come up with a standard form draft. And the aim was to draft the standard form contract related to technology and specifically softwares. As a result of this committee, which is called TEC for short, TEC. The TEC members then drafted the standard form, which is in brief. The front page is what you're on the screen now in the picture, based on AIAC and TEC, and they came up with the software development contract. Now, interchangeably, when I'm having this discussion with you guys, I will be using the terms SDC and SDA interchangeably, and what they stand for is Software Development Contract, FDC, and Software Development Agreement, SDA, which is what was typically referred to previously. But the AIAC refers to it as SDC, and if some of you guys want a copy of this, I'm happy to send it into the chat, and I'll post the link after this talk so that you guys can have a copy of it as well. It was launched in 2021, last year, 2021, last year on the 19th of November during AIAC's Alternative Dispute Resolution Week. It's free and it's available for download on their website online, and you can download it. However, caution should be used, and I'll explain to you why moving forward in the next couple of slides. So the AIAC standard form contract comprises of these four main terms, which are broken up into several elements. The first one being articles of agreement, which is pretty vague, standard, and simple, and it comprises of 4 articles. It then goes on to conditions of contract, which is quite technical and lengthy, and I'll show you guys why. There are blanks, which is customizable. Depending on the project and depending on the parties to the agreement, you can change it interchangeably. And then the execution page and the bulk of the form, of course, being appendices. Like most of you were listening to Tommy earlier, what he mentioned was for software development agreements, a lot of the terms such as project, timelines, milestone, contract payment milestones are all set out in appendixes. And the reason for this is to keep the contract quite standard with appendices as loose papers at the back, which can be put in and out depending on the type of project and depending on what the client wants. So with that being said, the articles of agreement sets out terms as well, like an umbrella, and I'm going to skip the other side so I can show you what it means. Okay, to give you guys a summary, the tabulation and the flow chart, which is on the screen now, is how the flow of the AIAC SDC goes. At the front, you have the articles of agreement, which is part 1. This is broken up into several elements, which is term, project scope, contract sum, definitions, and interpretation. Which sets out the heads of term and the main heads and terms of the agreement. This then sets up the platform to move on to conditions of contract, which comes in all the technical elements and the nitty-gritty with the legal jargon, of course. So you've got things like warranties, obligations, suspension of work, defects, testing, payments, variation, delays, liquidated damages, confidentiality, IP clauses, termination, and boilerplates. And lastly, again, the biggest chunk, appendices. So what I'm going to do is I'm going to take you through the AIAC contract, show you exactly how it looks like and when these specific clauses come in. So I'm going to stop sharing and I'm going to share with you the actual terms of it. So what you guys should be seeing on the screen now is a copy of AIAC standard form. This is the software development contract, which is, again, like I mentioned, you can download it from the AIAC website. And the first page essentially is a disclaimer, of course, to state that this is not, this is a template per se, essentially, which is what I want to reinforce here. It is a template and it's not a copy and paste document that every company and every software developer can use. And the reason for that is because different types of elements in contracts and terms might need to be either amended, deleted, included, added, and things like that. So it is something that is customizable and you should not rely on the contents per se and just sign it off. So the first page is essentially parties' names, which you need to fill out with a reference number on the front page as well. And then you go on to the table of contents. As you can see in the diagram, which I had shown you earlier, the table of contents is quite comprehensive. and it sets out exactly where specific clauses are located within this agreement. So this agreement is roughly about 49 to 50 pages long. And so it's quite comprehensive in terms of what is included. So the first page is articles of agreement when we get into the actual articles, where you have parties details, you've got recitals. What you see A, B, C, and D are recitals. These recitals set out the preliminary scope of work, who is engaging who. Like Tommy mentioned, it's essentially between a customer and a developer, a software developer, and the customer is engaging the software developer for the purposes of developing a specific software. The terms, the scope, the specifications will be included in the body of the agreement, and then specific elements which are technical would be in the appendix. Recital B then goes on to state exactly how much the contract sum would be. This is just a lump sum to give an overview of the agreement, and of course the breakdown of how the payment will be paid will be in the appendix. And then recital C and recital D sets out that they have accepted the customer is essentially appointing the developer for the scope of work. Now, recital D, if you see here, it states that if the parties agree that the developer is to provide an ongoing support and maintenance, then they need to execute a separate agreement, which is in appendix 6. This is an example of what may and should and should not be included in the agreement, because not all software developers will then go on to provide support, and who are using this agreement as a template need to be sure that recital D is removed. And then moving on, like I mentioned, the articles, which is the very first element of the agreement, sets out terms, the project scope, contracts, and the definitions. Now, if you can see, these articles are very brief. The paragraph is essentially Article 2 as an example. It just sets out that the project scope and specifications are in Appendix 1. And so the idea of these articles is to give you a summary of what is included in the agreement and where each of these appendix 2, 3, 4, so on and so forth. The definitions are also very comprehensive. So some clients may not necessarily require all of these definitions to be included. And so a great care needs to be taken to remove or add certain definitions which may be required depending on the project and depending on the software which is being developed. An example of this is clause 6.16 on the screen now. Good industry practice would differ depending, one, on jurisdiction, where your clients are from, where the parties are from, where is the company, where is the customer. Do you want to change the good industry practice? But what you see here is basically the standard, both internationally and in Malaysia. However, it can be amended based on what the parties want. There are also different types of elements after articles, which is the main top of the agreement, like I mentioned. There's conditions of contract. So this is where we get lengthy. The legalities of it, the legal jargon here is very comprehensive. There are things like warranties, indemnifications, which again are customizable. These are the standard, these are the basic, and this is what is included under the AIAC STC. As Tommy mentioned earlier, the important clauses which he has gone through are things which are usually in a bespoke contract, and they're also all in the AIAC STC. So it is covered under this as a template. An example of this would be the services which he's mentioned. So Tommy's mentioned that services is an important key element of the contract, scope of work, specifications. Under the AIAC STC, services are included under Article 2, which if I go back, you can see it. Article 2 on top here is project scope and specifications. And it basically makes reference to the project scope and specifications being set out in Appendix 1. So the actual scope, depending on which project you're doing, is actually not in the body of this agreement, but it is in Appendix 1. Okay, so I'm going to go to Appendix 1 to show you guys how it looks like and what that project scope should include. It doesn't give you a breakdown of any specifics whatsoever. So this is up to the customer and the developer to include what the project scope is, how the design of the software should look like. Attached should be drawings of what the customer wants the software to look like, how do they want it to work, what are the specifications and the specific elements that needs to be included. Are there specific functions which need to work, and a description of the functions. So this is a template, but some customers that we have advised previously include things with rather than functions. Again, like I said, this depends on what software. You could have a software for a mobile application, or you can have a software for an online platform where the functions would be different. And so depending on what you need, the AIAC's template actually gives you a breakdown of what you should be including, but these are customizable again. So if you see things like level of services, it depends whether the project is big or small. Not all projects would have very specific technicalities, and not all projects would include this much of information under the specifications. So if it is a smaller project based on the terms and conditions agreed to between the customer and then some of these elements which are listed in Appendix 1 would not be applicable. So if we go back to the conditions of the contract, what you would see is various different clauses, which Tommy has covered as well, which are in this agreement. Another one of those is project timelines. Now, project timelines under AIAC's SDC is pegged to the contract sum. Okay, I'll repeat that. The AIAC's SDC contract, the contract sum and the project timeline is pegged to the contract sum. So if we go to Appendix 2, you will see that how it is drafted under this agreement means for every stage of functionality or deliverable for the software that you provide, there is a deadline for a completion for that to be provided. I'll give you an example. The deliverable would be for the mobile application's functionality to complete the user testing phase. Or the deliverable would be to include X, Y, and Z function. Under the deadline, there would also be the installment payment to be paid, which means that the customer only pays the software developer after each task or deliverable has been achieved. Now, this is very important to note because significant amendments, not really significant, but certain amendments will need to be made throughout the entire body of this agreement. In the event the agreement between the parties is to pay the contract sum in a lump sum. Okay, so some softwares with the software developer and the customer choose, you provide this software for me. At the end of the user testing, at the end of the final testing stage, I will pay you or within a certain amount of days. Now, when that is done, that's considered a lump sum payment, and the contract terms and the payment sum would not be pegged to a milestone. All right, so that needs to be changed interchangeably here. Variation, the same goes for variation, which under this agreement is set out under Clause 9. So Tommy mentioned that it's very important to have variation clauses in software development agreements. And the reason for this is because throughout development of the software, the customer may want different functionalities included, removed, or changed. And so there is a variation clause in the AIAC's SDC. However, some clients do not want variation to be included, and this may be removed. Great care needs to be taken if variation clauses are removed, because throughout the body of agreement, it does make reference to variation in other clauses. So if you're removing anything in the beginning, in the middle, or in the end, or any of the appendices, legal advice needs to be sought to ensure that the remaining definitions under the clauses or the remaining corresponding clauses are either amended or removed as well. Tommy also mentioned testing, which is a very important key element for all software development contracts, regardless of whether you use the AIAC or if you make use of a bespoke contract. Now, testing stage includes different types of testing depending on the project. You can have an initial testing stage, a final testing stage, or an acceptance test, which is just a one-off test for everyone from the beginning to the end of the software to see how it works. Under the AIAC SDC, it's got something called an acceptance test, and then they also have failure to pass the acceptance test and criteria based on functionalities of what amounts to the acceptance test being passed. It's very technical, very comprehensive, and good. However, some softwares which are a little bit more technical will include 3 stages of testing. You would have the initial testing stage, which is usually a couple of months from development of the software, or it could be approval of designs. You then would have a user acceptance test, which is making use of the software to X, Y, and Z employees or users to test the software and see how it works. And then lastly, you have a final acceptance test, which is the acceptance test to pass off that the software is now ready to go live and it's ready to be handed over to the customer together with all intellectual property. So again, this testing stage will differ depending on what the customers want and depending on what the project needs. The AIAC's STC also makes reference to liquidated and related damages, which is LAD, suspension of work, which is an important clause in the event there's a delay or failure to complete the software upon a certain completion date. There's also confidentiality and intellectual property rights, data protection, which is important to provide who will take over ownership of the source code. Now, in all software agreements and in software development, the source code is what is important for. Please be aware that under Section 11 of this AIAC STC, which is what you're on the screen now, especially 11.7 and 11.8, certain data protection acts of different countries will differ. So Malaysia has the PD, the EU has a different regulations, the US have different regulations. And so what you choose, where you choose to govern your contract, or which laws you use to govern, depending on which end user is in which country and which end users are going to be using this data or providing their data. This needs careful thought and care and to be included. As you can see, there are a lot of blanks here for you to complete. And finally, support and maintenance. So support and maintenance is something which the AIAC STC already has incorporated into their agreement. They have the support and maintenance appendix under clause 11 and appendix 6. So if you see Appendix 6 sets out a support and maintenance as an appendix, which is to be signed simultaneously, depending on whether support and maintenance is provided upon execution of the agreement. This provides an agreement that after the software has been developed, the software developer will still continue to support and maintain the agreement. And then, of course, you have the usual boilerplate clauses under the agreement, as Tommy mentioned, which are all set out after clause 13. So in a nutshell, this is the AIAC's contract. This is the AIAC software developer contract. What is included in this, which is in addition to what is not so much covered under bespoke contracts, are these clauses. One being suspension of work. Some bespoke contracts don't cover that. They just cover delay and termination. There's a specific clause under clause 4 here, which is for suspension of work. We've also got invoicing payments, which is clause 7. Invoicing payments is specific to milestones and where payments are made based on milestones, not in a lump sum contract. This also has procedure of claims under clause 8. How do you claim if there is additional cost, or how do you claim if there is an additional time being requested for? And then they also have an upgrade agreement, which is very interesting because not all bespoke software development agreements have. This is under Appendix 5, and Appendix 5 is the upgrade agreement in the event an upgrade is required. So there's a template here to be used as well. So I'm just going to wrap up and go back to my slides. Included. Okay. So we've left off here, we've gone through the articles of agreement, the conditions of contract, which are included under AIAC's STC. This is a brief summary of what those elements are. And the appendices here is what's on the screen. So several appendices, which are quite helpful, but include a lot of customizable information, which are left blank for you to complete. And it is worth noting as a conclusion that although the standard form includes most standard terms and conditions, you need to be aware that certain terms are linked to different clauses. Some of the appendices are also linked to different elements within the contract. And so it's not as easy as following the template to just sign off on it without legal advice or amendment. Depending on the type of project you have and depending on the scope of work, certain amendments to the contract will need to be made. Each customer and project is obviously different. And again, like Tommy mentioned, different software development would entail different softwares. And so the review of the standard form should be sought to include specific terms to address your specific concerns for your particular project. Now, each project may require different terms, so just be aware that certain terms and elements are not mandatory and do not need to be included under your contract, and it's quite customizable depending on what the parties want. I hope that's been quite informative for you. And time permits, I think we'll move on to a quick Q&A session. I think there's a few questions here, so I'm going to hand the floor back to Anis. Thank you.
Thanks, Cassandra. Thank you to both of you for sharing and taking us through the new standard form of contract. We are a bit over time, but we hope you bear with us. I think you have a lot. I don't know about you guys, but I was more engaged as a participant than a moderator. So I don't know if that's why there's not many questions yet, but I did see a few. So first, I remember seeing in the chat, I think this one is for you, Tommy. The question reads, how about resulting copyright? When and where can I use them? I think this was asked when you were going through governing law and dispute resolution. So maybe the question can be, what would happen if copyright arises, or where would you find terms that cover this situation that will cover your rights in terms of copyright?
Yeah, actually, I've actually looked at the question. Thank you for the question. If I understand your question correctly, that would refer or relate to the software and the IP rights that arises as a result of the software development contract. How do you use it? How do you and where can you use them? Now, there is what we call the IP rights that is attributable to the development of the software. So for example, any source code, if the contract has or states that any source codes, programs, or anything, specifications, drawings that are embodied in the software itself, that would be the IP rights that are embodied within the software arising out of the course of the contract would be vested with, let's say, the client. And the client then would need to take steps to then register your trademark, your copyright, or even your patent. Then those IP rights belong to you and you can use them at your discretion.
Thanks for explaining, Tommy. I think the next question, Cassandra, one of our participants asked if they're engaging a website provider and certain modules are customized to suit their needs, can they protect the customized module so that the provider won't commercialize the module?
Yes, you can. So again, this depends on the type of intellectual property data protection clause you have under the agreement. If you remember correctly, there were two elements which I had described. One is variation. So if you are adding certain modules which are customizable at a later stage and it's not included as one of the functionalities under your software specifications, then it would be a variation. So what you would need, which at the moment the AIAC SDC does not cover, is that if there are any variations which include modules which are customizable by you, what happens to those in terms of its data and what happens in terms of who that module belongs to. This is considered something from the software, which in the event your agreement already covers that everything and anything to do with the software belongs to the owner. If that's the case, then what happens is even if there are any customizable modules, which even if it's a variation later on, would fall under ownership of the customer. If, however, there is a deferring clause which states that the software developer owes certain elements to the software, that's when a specific customized clause needs to come in to state that any variation of certain modules which are created at a later stage would then belong to who? Either the customer or the software developer. So this needs to be spelled out under the agreement to avoid the software developer from commercializing that module.
I'll open the floor for a few more minutes. Our speakers have kindly agreed to stay. Did anyone, maybe sometimes they write to you directly, some questions if I missed them out. Thanks for taking the opportunity, Karen Pugh. Let me check. I think this is directed to you, Cassandra. For the customization AIC standard form, will the numbering of the clauses be automatically updated when certain clauses are removed?
This is a very common question. I will highlight that the AIAC standard form, you can download it, but at the moment they only have a PDF copy. You can download a Word copy and you can convert it to Word. However, with the clause numbering, it doesn't automatically change. What AIAC is working on now is they're currently going to be uploading a customizable version, which I'm assuming the numbering clauses will automatically update because that can be quite a tough thing to do. The best bet would be to wait for that to, they haven't stated when, it just says that it's coming soon and that they will be issuing a customizable template online.
Thanks, Cassandra, for answering that. I think that reminds us of, as you mentioned, we have to be wary to engage lawyers to help us because it's not customized. That's why you call us and we can help you do the numbering and all the formatting of the agreements. So I think that's it for questions. Before you guys go, let me just make a few more announcements. Thank you again to Tommy and Cassandra. Before we conclude, please join us again for our upcoming talks. Our next talk is scheduled on the 28th of September, so the end of this month, and it will be covered by our criminal defense team, by our associates Vivian Fan and Wong Chien, and they will be covering what to know if you're stopped for drink driving offenses or other road traffic offenses. So it's very relevant, just not to those who are facing the law, but you may know someone, and it's also good knowledge to have in hand because those things happen very fast, obviously. So it'll be something good for you to join. If you want to join, you can scan the QR code and sign up for our online talks. You can, secondly, please fill in your feedback and tell us what you thought of our talk. The link to the form will be posted in the chat. Do follow our social media accounts. And fourthly, if you would like to speak with our lawyers, we offer complimentary 30-minute consultation over the telephone or video conference. Please fill in the form on our website. The link is also posted in the chat. I'll leave this up for you to scan if you want to. Maybe some of you were shy to have some questions just now, so you can use this opportunity to write them down and seek consultation with either Cassandra or Tommy, and they'll be happy to answer your questions. And again, to our guests, thank you for joining us. We hope you have found this session informative and useful, and we hope we see you in our next talk.